Welcome to Law Line with your host, the distinguished New York lawyer, author, and lecturer, Alan Schneerman. Each week, Law Line will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schneerman.
Welcome to Law Line. What recourse do you have if your attorney has done something unethical or wrong in handling your particular case? Today we'll answer that question when we learn about what the Disciplinary Committee, which handles these complaints, does. Joining us as our experts are Michael Gentile, Chief Counsel of the Departmental Disciplinary Committee, and Abe Abramowski, a professor at Fordham Law School who teaches criminal, procedure, and legal ethics. Welcome, gentlemen.
Well,
Michael, what does the Disciplinary Committee do? What's its function?
well, essentially the function of the committee, Alan, is to hear those cases and make judgments about lawyer misconduct, and ultimately, if the case warrants it, to adjudicate the guilt or innocence of a lawyer before it.
Well, is it a trial? Is it, I mean, what really is it? What does it mean to our viewers that there is this Disciplinary Committee?
Well, what really happens, Alan, is if there is a grievance, if a citizen has a grievance against a lawyer, a client has been wronged in some respects or feels they have been wronged, they're entitled to bring a complaint to our committee. And the staff of the committee, I'm chief counsel to that committee, and I have a staff of lawyers, of professionals, who very much like a district attorney's office in a criminal matter will evaluate the complaint and determine at what level the case should be prosecuted. And in answer to your other question, if the case is a serious enough one, and the lawyer, we seek to have the lawyer publicly disciplined, and by that I mean either censured, suspended, or disbarred by the appellate division, which is the court that admits a lawyer to practice, and it's also the court that ultimately would have the unpleasant duty of taking away a lawyer's license. If a case needs that kind of treatment, ultimately it has to be tried. A lawyer is entitled to a hearing before a committee, and that issue of his guilt or innocence on those charges would be adjudicated in that fashion.
And the lawyer is also entitled to have his attorney represent him, isn't he?
Absolutely.
And that's where we bring Abe in.
Well, the thing is, there is one area that wherein lawyers do not get a hearing, which is one of my pet peeves, and that's automatic disbarment for the commission of felonies. I think it's ironic that a hot dog vendor on up will get a hearing, will be represented by an attorney, while an attorney himself, once he becomes a defendant before the grievance committee, which goes up onto the appellate division, he is automatically disbarred without a hearing.
Abe, you teach legal ethics. Can you tell our TV audience, what do you mean by legal ethics? What does those differ than regular ethics? What is a lawyer held to one standard and a doctor held to another standard? What are we talking about here?
Well, I think that a lawyer should be held to a higher standard in the fact that we are a profession. Now, do I go there in the morning and take an individual who has no ethics and instill ethics in him? The answer is no.
Okay.
What I do is, my primary aim is to make sure that an individual who is willing to serve the public will never find himself in a position where he unwittingly commits a wrong. And there are various pitfalls in the practice of law. And I'll give you an example. Let's for example take a criminal case. You have a young attorney, he's just out in the field, a defendant approaches him, and he says, I will pay you contingently. If we win, I will pay you $10,000. If we lose, I won't pay you anything.
Now that's for a criminal case.
That's for a criminal case.
Okay.
Answer is, under no circumstances may you take a contingent fee. Because if you do take the contingent fee in a criminal case, you will find yourself before Mike Gentile.
However, now, where are these rules promulgated? Who makes up these rules, what's right and what's wrong?
All right. The thing is, overall, we have a code of professional responsibility. And the code of professional responsibility is pretty much uniform within all the 50 states. In addition to that, technically speaking, it's the judiciary law of the state of New York, particularly Article 90, which controls the conduct of attorneys within our state.
Michael, when a claim comes before you, what is the procedure? Can you just give us a nutshell what has to be done? And if you could also address the issue, when does a client know that his attorney is doing something unethical? I mean, he doesn't know the procedure. He hasn't read the judiciary law. What can you tell them to help them in evaluating this?
Well, I think the answer to your second question before your first, Alan, is that generally speaking, as with most conduct in human existence, we pretty much intuitively know when something is wrong. Lawyers themselves, even lawyers who have not studied the Code of Professional Responsibility, I think by and large 90% know that they've done something wrong when they've committed an act which comes before us that is subject to our scrutiny. The same is true, I think, of a client in evaluating his attorney's conduct. If something doesn't strike you as being right, if something doesn't strike a client as being fair play, for example, it generally speaking will be violative of the Code of Professional Responsibility. That's not to say it always will be, and maybe there are technical reasons why it won't, but I think a good gut reaction, something that's outside the parameters of fair play, should bring a client to my agency, and we will tell them candidly and openly what exactly it is that their grievance should be. In other words, a client doesn't have to worry about coming to the disciplinary committee and having to have a degree from Harvard Law School. He can come to us and we will sit him down with a lawyer, and that lawyer will evaluate the claim and the facts and determine whether or not there's a viable complaint.
Abe, I just want to, if I may ask
Sure.
a question. I know you want to comment on
Yes.
that, but first, we got a letter in that an attorney represented to a husband and wife who was having problems, that if they resolve all the issues between them, he can represent them both. Is that ethical?
No, and traditionally it is not ethical to represent both sides of a party, of an action. And the reason being is that when you're an attorney, the notion is to give your client the best representation possible. Now, there are certain cases wherein, even though it appears that there's a conflict, there is no conflict, and there are exceptions. But in the usual case, my recommendation is when in doubt, represent one side only.
Well, is it unethical for an attorney to represent both the husband and wife?
I would say that, well, maybe I should let Mike speak about it. I would say that technically, it's probably not unethical, okay?
That was going to be my next question.
But realistically, it is unethical.
My next question was, if it's unethical, do they come before your committee?
We have cases, obviously, of what we call conflict of interest, where there was what we call divided loyalty in the lawyer's mind. In other words, he can't effectively serve the dual interests of both sides of a matrimonial. And we know how hot matrimonials can get. And oftentimes, even though technically, as Abe points out, there is some cases that have said a lawyer can represent both sides of an uncontested matrimonial. Pretty much as your facts described, Alan. The husband and wife get together, they resolve the major issues before them, between them I should say, issues of custody, issues of dollars, and they come to a lawyer who's a friend of both of them perhaps in a very amicable way and say, look friend, we've come here, we're your friend, can you write it out for us? Put it in legal terminology, we just want to save ourselves a few bucks. Certainly it's a laudable aim for the legal profession to try to save litigation costs, try to save legal fees for litigants. But I think, as you know, and as I'm sure Abe knows, matrimonial law, especially matrimonial law, is such a hotly, an emotional issue that what may be resolved one day becomes unresolved the next day, in one phone conversation perhaps. And then what do the litigants do at that point? They've all disclosed all their personal information to one attorney. Now he has a divided loyalty. He has to represent one side of that dispute. It may be legally correct to do so, or technically permissible, I should say, but it's very unwise.
And you don't recommend it,
I
obviously.
don't recommend it.
I have another conflict question for you from another viewer who wrote in. She is buying a house, and she went through a broker, and the broker recommended an attorney to her. Well, she wanted to know, should she take the attorney who the broker recommended, because she thinks, well, the broker really wants the deal to go through, and if she takes that attorney, he may have another interest.
The general answer to that question is that it's usually some sort of conflict or potential conflict there. Obviously, in the situation where you have a broker recommending the attorney, he has one interest, the attorney has another interest, the client has another interest. It's very much a situation like the matrimonial situation, which is fraught with all kinds of potential dangers for the client. And that's the person that we're really here to protect, Alan. My job is not to punish lawyers. It's really to perform a function which as a byproduct, does punish lawyers by taking away their license, perhaps, by suspending them. But the law is clear that the function of the disciplinary committee is to protect the client, and that's what we try to do. And I think a lot of these advisory things that we've been saying about matrimonial lawyers and the real estate broker situation really are just good common sense.
And here in the broker area, again, technically it is legal. Okay, technically it is ethical. But on the other hand, I mean, you don't have to be a genius to realize that this particular broker is recommending this particular lawyer because he wants this particular deal to go down. Right?
Abe, legal ethics is in the news today. I read an article in the New York Law Journal about an attorney who went to Bhopal in India and of the abuses that he saw there from attorneys all over the country. Abuses such as even paying for cases. What's your opinion on that?
I think it's despicable. I think that solicitation of that form is pretty much the closest thing to being a maggot in our profession. I think it's not the first time, by the way, that it happens. It has been known to have occurred whenever you have air accidents, aviation accidents of major proportions. Somehow, through some miracle, certain folks appear at some remote islands. But the thing is, I'm not so much concerned with the Indian situation, because I think let the Indian authorities deal with that. I'm concerned with the situation right here in the state of New York. And the one thing that I want to relate to the audience, well, actually two things. I think most lawyers do a very good job for their client. That's number one. Number two, I think we're very lucky to have Mike Gentile as the head of the Disciplinary Committee for the First Department. Because not only is he a person of great intelligence, but he's a very fair-minded individual. And you have to understand that in this area, unlike the criminal court area, he's a prosecutor with immense discretion. Unbelievable amount of discretion.
Can I ask the prosecutor a question on that? Well, how do you feel about that?
About the compliment?
About the compliment, I'm sure that you'll take in a dignified manner, and you thank him. However, from your point of view, it's often said that the legal profession is self-regulated. Well, here you're in a position as chief counsel to the Disciplinary Committee. There are accusations, and that's all they are, that these abuses are going on. How do you feel about that? What are you going to do, if anything?
Well, I'm under certain constraints about what I can tell you I will do about particular cases, but in general, in a general sense, I think that any time a situation arises which is clearly, or could be clearly, a violation of lawyer ethics, of the Code of Professional Responsibility, we don't have to wait for a complaint, Alan. I don't need a letter. I don't need a letter like Perry Como used to get letters. We get letters. I can pretty much open up a file on my own authority, what we call in legal jargon a sua sponte complaint, based on the court giving me certain powers in their court rules to do so. In other words, if I am made aware of a situation through any means of a violation of the Code of Professional Responsibility, I'm not constrained to wait for a letter, a signed letter from someone complaining about it. So I hope that in a general sense answers your question.
It does. The only comment I want to make, I'm sure that most of the attorneys in India held themselves up to a very high professional standards.
Well, I don't, again, I don't know all of the attorneys that went to India, and I don't know how they behaved. But I think that their primary interest in going to India was not to protect the Indians. I think it was to enhance their financial gain. And I think the way it was done, or at least the way it was depicted, to me was rather despicable.
Abe, under the same vein, if regarding solicitation of cases and personal injuries, if someone's in a hospital, can an attorney come up to that person in the hospital and solicit his business?
Okay, an attorney cannot come up to him affirmatively. In other words, he cannot just walk from one room to another and find people and just say, here I am, take me. On the other hand, if this particular individual calls an attorney in, either via himself or via his family, the attorney may visit him.
Well, we have a new field in the media developing now, as you might know, Alan. It's the field of lawyer advertising. And I think the question you just put to Abe is relevant to that, because there's a whole separation in the law at this point between lawyer advertising and what we just described, which is a solicitation. One you can do, namely advertising, and in-person solicitation, face-to-face, just very much as we're talking right now, is prohibited. But that's becoming even more unclear because the courts are ruling on a daily basis on different cases. In fact, there was a recent Abel give me the citation as a professor of law, a recent Court of Appeals case, the highest court in our state, which essentially said that you can solicit by mail. This was a case involving I think it was the Kansas City hotel disaster.
I read the case.
And essentially what the court said is that that's allowed. It had never said that before. So I think the whole area of what lawyers can do in order to get business and to make themselves more available to the public is changing somewhat. But it hasn't changed to the point where you can go to a hospital unasked for and solicit a patient.
Let me ask your personal opinion on something, Michael, if I may. I saw on television that an attorney out west was advertising. And what he did was he rented a plane, and he got a banner, and he had the banner out the back of the plane, and they flew over a large football stadium with 100,000 people. I mean, how do you feel about that personally as an attorney?
Well, I think if the way you put the question, I'd have to say that it's not my cup of tea. I mean, it's not exactly what I have an image of attorneys doing. But then again, as in my official capacity, I have to enforce the law as it presently is. And if the courts are going to say that it's okay for an attorney to exercise his First Amendment rights, and lawyers are human beings and citizens of this country as well, and they have First Amendment rights, have the right to free speech, I have to abide by that law. I don't have to like it, and I don't think it's aesthetically pretty for lawyers to advertise in that way, but certainly it is presently allowed.
Dave, can you comment?
Yeah, well, what we're talking about is what is known as commercial speech. And commercial speech is part of the First Amendment, which is protected. Now, I think that it's in poor taste to do what this gentleman did, and I wouldn't do it myself. Yet the question is, technically, does it reflect poorly upon the administration of justice? We do have a provision, which is a catch-all provision, that says that yes, you are allowed to advertise. However, you're not allowed to puff, you're not allowed to self-laud, and you're not allowed to adversely affect.
By puff and self-laud, are you referring to that if I came on a commercial and said, I'm the best attorney in this area on personal injury law, would that be a puff?
That would probably be a puff unless you could back it up. Okay? Now, the thing is, it's very, very difficult to define what puffing means. Because let's face it, why do lawyers advertise? I mean, you're not going to advertise in order to say that I'm not a good lawyer, right? So we're going to be somewhere between saying I am an adequate lawyer to where I'm a very successful lawyer. And somehow the message is going to get across that he's a rather successful lawyer.
It's also true in this state anyway that there's no such thing as a specialist. A lot of lawyers wrongly say in their advertisements that they are specialists in criminal law, specialists in real estate, specialists in this or that area. According to the rules as they presently exist in the state of New York, there can be no such claim because there are no specialties certified within the state of New York. So that would be a violation of the Code of Professional Responsibility. But I think more importantly than these technical violations is what the court's been focusing in on now, Alan, is whether the claim is false or misleading. Again, we get back to the client, the consumer of legal services. Is he being sent in the wrong direction by a false or misleading claim? And those are the kinds of things that the court is still coming down on, and certainly those are the kinds of things that lawyers cannot do at this date even.
Michael, is one area of law, does that have more complaints than another area? Does securities attorneys get more complaints to the committee than personal injury attorneys or something of that nature?
That's an interesting question because it's not so much the particular area of law, Alan, as it is the type of practice, I think. In my 4.5 years as chief counsel to the committee, I can tell you that I think it's the kind of practitioner, and I'm not saying whether it's a matrimonial lawyer, a real estate lawyer, or a criminal lawyer. It's the nature of the practice. If it's a one-person practice, if it's a small practice, sometimes people who are involved in high vulnerability. What I mean by that is a lawyer who handles a lot of money, a lawyer who has a lot of client contact. A lot of major firms have 200 and 300 attorneys. They rarely get to sit down with a client on a regular basis or routinely. They rarely have to take a client's money and safeguard it, so they don't fall heir to all those violations that sometimes tempt other lawyers, namely violation of escrow provisions, for example, or of fooling around with the client's money, to put it in the simplest terms, because they simply don't see it and they don't get it. I'm not saying that big firms are less moral or more moral than small practitioners or single practitioners, but there is much more vulnerability in a single practitioner than there is in the big firm person. The best example I can give you is one that I've given before, is that if you took the best criminal lawyer in the city of New York who represents gangsters and racketeers, and you took the best matrimonial lawyer, each of who represents the wealthiest people in matrimonial cases, it would be very likely that the matrimonial lawyer would have more complaints filed against him. Not because matrimonial lawyers are less ethical, but because the nature of the practice is such that people make complaints against matrimonial lawyers. There's hotly contested issues. People are angry with each other. A mob lawyer or a racketeer's lawyer very rarely gets a complaint to my agency. They seem to take care of it by themselves.
Well, we'll leave that question up in the air. Abe, can you comment on it?
Yeah, I think I can. I think by and large, it's the little guy who is accused and comes before the grievance committee. And that's something that to a certain extent I think is unfortunate and unfair. In the major firms, the major partners are very much insulated from client contact. And they can afford to have any number of clerks to say, look, this case, the statute of limitations runs out at this particular date. This individual is going to come to see you, and so on and so forth. When you're dealing with a small law firm, 2-man, 3-man, who are general practitioners, these are the guys that ordinarily, I think, find their way before the grievance committee. And oftentimes, I think the grievance committee, quite frankly, is used by the clients as a collection agency. What happens is, and I know that may be a little bit of a controversial statement.
Let me just stop you for a second. I thought that the grievance committee had nothing to do with fees, that they send that to
They have nothing to do with fees, but the client doesn't know that. And what the client figures is that, well, you know, I asked them for half of my money back or 3/4 of my money back because I was not satisfied with the result. Now what I'm going to do is I'm going to put a little heat on this particular lawyer. And a letter or a phone call goes.
What are the most common complaints that you see that are made by clients against attorneys?
I think most of the complaints have to do with money.
Return of fees?
He overcharged me. He told me it was going to be $1,000, then he took $5,000. He took money from the escrow account. Most of the time it revolves in and around money. Very seldomly do you see a complaint grounded upon jurisprudence or a disagreement in philosophical opinions.
I would agree that many of the complaints involve money, but I think the vast majority of complaints, I have to differ with. They involve claims which are really almost like hurt feelings. Clients, my lawyer doesn't talk to me. I call him on the phone and he never returns my call. He's had this case for 2.5 years and I don't know what he's doing with it. Sometimes we get complaints that are very frivolous. I mean, I've gotten complaints from, for example, as a hypothetical, from a tailor, saying that a lawyer didn't pay to have his cuffs altered. He didn't pay a $10 bill to have his cuffs altered. And oftentimes, people feel that simply because a lawyer has a license to practice law, and simply because we exist as a scrutinizing committee, that they can use leverage on a lawyer in all other areas of the lawyer's personal life. This is not so. A lawyer has a private life and he has a public life, a professional life, I should say. And a lot of these complaints are really very, very much geared to have a lawyer react in his personal life in a certain way. They're leverage devices, and we don't handle those.
Michael, so there's no confusion here. When a client says, I'm going to take you to the Bar Association, does he take them to your committee or to a different committee?
I'm so glad you asked that question, because as of 1980, the Bar Association, any Bar Association, no longer has any jurisdiction in the First Department, which is Manhattan and the Bronx. It's the Disciplinary Committee now, which is a state agency, an arm of the Appellate Division of the First Department, which has exclusive jurisdiction over all complaints against lawyer misconduct, with one minor exception, and it's one you alluded to before, Alan, the case of fees. In that situation, if it's simply a fee dispute, if a lawyer and a client have a misunderstanding as to what was decided would be the fee and what was suggested and what was the conversations. For example, a person may come in and say, you promised that the fee would be $1,500, he says to his lawyer. In a matrimonial case, the lawyer says, well, I didn't tell you that if we had to go to litigation, it might be $1,000 more. So they have a disagreement about what the fee should be. We send those cases to a joint fee conciliation committee for arbitration. We're putting the two parties together and hoping to resolve the matter financially between them without going through a disciplinary proceeding. Excuse me.
Abe, we have a lot of lawyers who watch the show. What's your advice to them to avoid complaints to Michael's committee?
Well, I think the best thing to do is to absolutely formalize the relationship with the client ab initio, meaning in the beginning.
The lawyers know that, right?
If they're lawyers, they'll know it. And the notion is, if you can put it in writing, it's even better. This is what I'm going to charge you. I'm going to charge you either X dollars per hour. I'm going to charge you X dollars for the case. I'm going to charge you a retainer fee for the first 50 hours, and then so much and so much over and above that, so that there is no
A
misunderstanding.
written agreement signed by the lawyer and the client?
That would be preferable. That would be preferable.
And Michael, your advice?
I agree with that. I think that in many of these fee disputes and these neglect cases, if there was some formalizing in writing of what the schedule was, what the fees would be, there'd be less problems for the lawyer.
Now, of course, there's certain areas wherein it's almost impossible to do. In the criminal law area, it's very, very tough. If you have an individual that comes over to you and he says, well, I was locked up on a burglary case. Well, you don't know how many other cases he has pending. You don't know what his prior record is. You don't know how intricate the case is. So to immediately sit down and draw up an agreement saying, because in criminal law we talk in terms of years, not hours, right? It's a little bit more difficult. But in the commercial area, I would suggest ironing it out on paper.
Michael, on a show that we had a question regarding prosecutorial misconduct, where the district attorney actually withheld evidence from the defense and the court. Does that come under your committee?
It certainly would. I think a violation of that magnitude, if proved to be an intentional one, would certainly be a violation that we would look at. A prosecutor I was a prosecutor for 10 years in the district attorney's office, so I have nothing against prosecutors, and I'm very much a part of that brotherhood. But I will tell you that that violation is probably the most egregious that a prosecutor could commit, to deliberately withhold evidence which would tend to exonerate an individual.
What would happen to him?
Well,
Quickly.
it's quite. He probably would be investigated and perhaps even charged formally.
Hey, can you comment on it fast?
Well, I think I can. I think the odds of him being prosecuted are about 1,000 to 1.
Abe Abramowski, Professor of Law at Fordham Law School, and Michael Gentile, Chief Counsel to the Disciplinary Committee, thank you very much.
Enjoy.
And thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnerman. Mr. Schnerman will be back with you again next week at this same time.